Wolverhampton City Council and others against London Gypsies and Travellers and others. Respond.
Thank you, my Lord. As the Court knows, Liberty is an organisation that campaigns to protect fundamental rights and freedoms. It's grateful for the opportunity to intervene in this appeal, and it seeks to ask one short question, which is relevant in our submission to Issue 1, namely whether a court can lawfully make a final injunction against newcomers, even when that injunction is likely to interfere with the human rights of newcomers, and there hasn't been any assessment of the individual facts of their case. To make that point good, we're going to make 2 points. The first is, in GRT cases where Article 8 rights are involved, in protest cases where Articles 10 and 11 are involved, an individual assessment of proportionality is required. And the second point is that a court, at first instance, is singularly ill-equipped to make such a category assessment as arises in these cases. And it may be apparent to the court straight away that these issues really apply in a world where, to answer my Lord Reid's question, the Human Rights Act remains in force. But even if the Human Rights Act were to fall away, Liberty's submission is that because fundamental common law rights are involved, such as the right to a home, the right to respect for one's ethnic identity, the right to freedom of expression, Section 37 would still require this type of proportionality assessment. To turn to my first point, Liberty's argument is that final persons unknown injunctions frequently do involve severe interferences with the rights of a large category of people. Indeed, in that sense, they are completely different to the type of targeted order that has been raised in argument by my Lords Lord Briggs and Lord Kitchen, such as freezing orders, Anton Pillar orders, and possession orders, which are targeted at specific people. Persons unknown injunctions can be put in place across vast swathes of land, entire boroughs, as in this case, entire parts of the strategic road network, as in the National Highways case, entire branches of petrol stations across the country in other cases. Such injunctions don't just regulate in protest cases violent protest or indeed disruptive protest, but can also regulate lawful protest and peaceful protest. And if I can give one example of that, the court has the UK oil and gas injunction, which prohibited gathering and loitering on public land, as well as, and separately too, obstruction of entry onto private land.
Have you given us a reference to that?
The reference is EF 1945, paragraph 2A. 1945, my lord. And there's one particular case which exemplifies these concerns in my submission, and that's the case of Gillian McGivern, and that's at tab 17 of the Authorities Bundle, EF 2369. Ms McGivern was a solicitor who visited a protest site to seek instructions from those who were present. The order that she was said to breach is at EF 2371, paragraph 12, and she was said to have become a defendant upon entering an exclusion zone that applied under that order for around a half an hour, I think. It's paragraph 23 of the case. She then became subject to prosecution and contempt. She had to self-report to the Solicitors Regulation Authority. She had to cease working for her firm pending the resolution of the proceedings. The decision to prosecute her in contempt wasn't taken by a public body such as the Crown. It was taken by a private company seeking to uphold an injunction. And she had no opportunity to argue the proportionality of the interference with her rights at the time that that order was made. And that's why, when one looks at the Friends of the Earth witness statement, Mr. Timms, tab 22, EF 1792, paragraph 19, it's clear that persons unknown injunctions in the protest context lead to less protest. And because human rights are involved, our submission is that individual assessment of proportionality must follow. That's clear in the GRT cases, for the reasons given by Lord Justice Coulson in Bromley, that my learned friend Mr. Drabble has taken us to. It's also clear from the judgments of the House of Lords in Porter, as my learned friend Mr. Drabble reminded us. And it's also clear from the Strasbourg cases which are cited in Bromley and in Porter. Can I give the court one example? It's the most recent in the bundle, Winterstein. And the relevant passage are at EF 5245 to 5246, because what that shows is in a GRT case, simply falling within a category, such as breaching planning authorisation, isn't enough to show that an interference is proportionate. A court also needs to consider factors such as the length of time of an encampment, the community that's being formed, the consequences of removal, the risks of becoming homeless, the vulnerability of the group, and the proposed manner of the removal. All of those are individualised matters. And the same applies in the protest context. For the reasons given by Mr. Justice Nicklin, we say in Canada Goose at first instance. The reference here is EF 2273, paragraph 136. The fundamental problem, as Mr. Justice Nicklin said in protest cases, is that it treats all protesters as a single class, not as individuals. And it leads unjustifiably to an interference with the right of protest of individuals who are doing nothing wrong. See Ms. McGivern, see those protesting lawfully. And that's because, as a matter of principle, when one exposes a protester to a tangible fear of prosecution for expressing opinions, that interferes with Article 10. That's clear from a number of cases, most importantly from the Kudrovicius case that my Lord Reid has looked at recently. And the reference here is EF 4984, paragraph 145. And once again,
Sorry, could you just give me that page number again?
EF 4984,
Thank you.
paragraph 145, which makes a point that exposing a protester to prosecution interferes with their rights. And then paragraph 155 for the necessity to look at the individual facts in a proportionality analysis. And so what matters in a protest case when one looks at proportionality is the extent of the disruption, the nature of the protest, the likelihood of violence, the value of the criminal damage, to use the example in the Colston statute case. All of these are the matters which require consideration before an interference with a right is justified. And that brings me to my second point, which is how, as a first instance judge, able to properly carry out that kind of individual fact-sensitive proportionality analysis. And we note that below, the Master of the Rolls made a comment in his judgment at paragraph 105, appendix page 453. In that paragraph, the Master of the Rolls commented that the property rights of the landowner are concrete, whereas the rights of the GRT community members in the future are abstract or putative. And while we respectfully disagree with that description, with those adjectives, because we say that underlies the reality of the rights involved, the fact that rights can only be looked at in an abstract way is a problem. It means that an individual fact-sensitive proportionality analysis can't be properly carried out. And insofar as he's right that the future rights of the GRT community members are abstract, so too are the future property rights of the landowners or the future rights of the local authority dwellers. Realistically, what's involved in these cases is looking ahead in a category way and putting in place a general measure, not an individualised proportionality analysis. And whilst that is something which is acceptable from a legislative assembly, see the judgment of this court recently in the Northern Ireland buffer zone legislation case, it's not, in our respectful submission, appropriate for a first instance judge. Now, the Northern Ireland abortion rights case is now reported at 2023 to WLR 33. But to give a few examples in the papers of how that case was resolved, and they'll be very familiar to your lordships. At EF 3540, paragraph 29, my Lord Reid noted that previous cases have showed that general measures can be proportionate, but those were all examples of parliamentary measures, such as immigration rules, employment tribunal fees, benefits legislation. And then the court relied on animal defenders in Strasbourg, EF 3542, paragraph 34. And of course, in that case, what mattered was the adequacy of parliamentary review. Then the court went on to look at UN Committee on the Elimination of Discrimination Against Women, academic research, and importantly, the detailed consideration of the bill in the Northern Ireland Assembly. All of those things, all of those tools are available to a parliament, but aren't available to a first instance judge. What is involved in general category measures are complex issues of policy and guidance, constitutional questions of parliamentary review, and a difficult balancing exercise. And importantly, Parliament is democratically accountable for such a decision, whereas a single first instance judge isn't. And so that's why the importance of alternative measures, such as bylaws in the GRT case, or in the protest case, as we cannot ignore the fact that politicians are currently looking carefully at the steps that need to be in place to ensure that there are adequate safeguards for the rest of the community. That is the appropriate place for these issues to be properly determined, not in our respectful submission by a first instance judge. And so that's why we say the Court of Appeal in Canada Goose was correct at paragraph 93, EF 2307, to express concern about the use of the civil jurisdiction of the courts to control ongoing public demonstrations by a continually fluctuating body of protesters. And that comment, of course, echoed, did it not, the comments of Lord Bingham in Laporte, EF 3752, paragraph 52, that the creation of controls on protest that go beyond the criminal law should be affected by legislative enactment and not judicial decision. And realistically, that only leaves one point for me to address, which is that in these cases, in the future, an individual protester may be able to come back and ask for review. But we say at that stage it's too late, as Ms McGivern's case shows. The litigation is formally at an end. Their rights have formally, and to use the adjective, finally already been determined. And of course, we respectfully echo the procedural concerns of Friends of the Earth as set out in their oral submissions yesterday. And for all of those reasons, my Lord, and those set out in the cases of the Appellants and Friends of the Earth, Liberty respectfully invites the Court to allow the appeal. Can I assist the Court any further?
I think not. Thank you very much, Mr. Bunting. As always, the Court is grateful to interveners for their assistance.
Thank you, my Lord.
Now, Mr. Giffen, before you begin, there are two matters I should mention. First of all, I think for everybody's comfort, the Court will take a 5-minute adjournment around about 11:30, 11:45, if you find an appropriate point in your argument. Secondly, obviously, we appreciate we've only heard one side of the argument so far, and we're looking forward to hearing the other side of the argument. It might be helpful if I were to say this to you. If we were to be persuaded by Mr. Drabble that the Gamble argument doesn't work in relation to final injunctions, then there's a question as to whether that is necessarily the end of the story. The question we would like to consider in that event is whether there may or may not be a principled basis for the possibility of making an order of the general nature that we're dealing with, notwithstanding the absence of service and therefore the absence, it seems, of jurisdiction to make a final order. I hope in the course of the submissions we hear on behalf of the respondents, you'll also deal with some other matters that arose yesterday. One is if such an order is possible in theory, then, and I think it would mean that we would be looking at what's substantially was a form of order which doesn't neatly fit within established categories. There would have to be a compelling justification for making such an order, and a question has obviously been raised as to whether there is such a justification given the range of statutory powers that are available in the travellers' context to local authorities. Another question which arises in the travellers' context is whether local authorities can be regarded as coming to the court with clean hands to apply for an equitable order if they have failed to comply with statutory duties in relation to the provision of sites. And it may be that if some form of order is a possibility, those are matters that need to be considered.
Yes.
And then there are some practical issues that have been raised in the course of yesterday's discussion, if such orders are possible, relating to the protections that would need to be built into them, probably by conditions. One concerns the duration of such orders. Another concerns how the court should be satisfied in relation to the justification for making an order rather than expecting the local authority to exercise other powers, and as to the local authorities coming to the court with what can be regarded as clean hands, and then as to whether there are other protections which are necessary as a matter really of good practice. For example, the point raised on behalf of Friends of the Earth in relation to the liability of defendants for costs. So there's a little shopping list, as it were, for you and your colleagues.
Well, I'm grateful. As between the respondents, as obviously I'm going to make the first submission, followed by Mr. Anderson and Ms. Bolton, and we've agreed I will try to take approximately two hours. In the light of what, in particular in the light of what my Lord just said, what I'm going to do, because time is a little tight, is to, first of all, to take our printed case as read and attempt to be responsive to what the appellants and their supporting interveners have said. I'm going to do so under 5 basic headings, as well as covering some more miscellaneous points, and it might be helpful if I just start by giving you my proposed route map and indicating at what point I'm going to try and deal with the points my Lord has raised with me this morning. So the 5 headings. The first is, which is going to be fairly brief, is the need for the appellants, given what they've accepted as to the breadth of Section 37, to show some clear principle or settled practice which closes the door altogether to final injunctions in newcomer cases. And I emphasise altogether because that is the nature of the way in which these proceedings have come to your Lordship's court. We are here because the appellants assert an absolute proposition that no such injunction may ever be granted properly. My second heading will be my learned friend Ms. Harrison's argument that the Gamble principle is entirely wrong, whether considered at the final or the interim stage, because it is inconsistent with natural justice. And under that heading, I'm going to examine Cameron, obviously a key case. I will also go to a Court of Appeal decision called M and the Lord Chancellor, which, as far as I'm aware, is the only decision which confronts these issues directly. And I will also go to what my Lord Reid said on this subject in this court in a case called A and the BBC. My third heading will be to deal with my learned friend Mr. Drabble's less far-reaching submission, which does not challenge Gamble directly, but seeks to confine its operation to the interim rather than the final stage. And I will be suggesting that the attempt to draw that line is contrary both to principle and to practicality, and I'll seek to show the court that it makes a nonsense of how the matter was actually approached in the two leading cases of Bloomsbury and Ineos. My fourth heading is convention rights, where I shall be concerned in particular to seek to refute the suggestion made by my learned friend Mr. Bunting just now that the operation of newcomer injunctions is intrinsically incompatible with principles of proportionality and how they should work here. And I'll go in particular to the decision of the House of Lords and the speech of Lord Hope in Attorney General and Punch in order to show how proportionality works at a stage when a party who may be affected by an injunction is not yet before the court. And if time permits, I will show, or at any rate refer the court to a selection of cases which demonstrate, in my submission, the grant of newcomer injunctions on a careful and principled basis in a variety of factual contexts. My fifth heading is then spycatcher and the injunctions operating in persona. Now, I was hoping to leave that, or suspecting I would need to leave that quite largely to my learned friend Mr. Anderson, but I will, in the course of that, try and deal with your lordship's point about what if I'm wrong on the main issue, as it were. And then under the miscellaneous points, I will try and cover some of the points which my Lord has put to me just now. I think Mr. Anderson, I'm anticipating, is certainly going to say some more about safeguards, because you will see, I hope, from what he shows you, that in the Wolverhampton case in particular, with the assistance of his learned junior, who sought the injunction, a very sophisticated and careful set of safeguards was put into place. But I will be reminding you, lordships, that we are looking here at the sort of absolute proposition that there can never be such injunctions. So, first heading, my learned friend Mr. Drabble, as I understand it, accepts that Section 37 is itself broad enough to confer a power to grant newcomer injunctions at any stage, i.e. that there is jurisdiction in the strict sense, to adopt the language used in Fury. His case,
well, I'm not sure he does. As I understand it, his final position was that the implication of Fourier and the authorities cited in Fourier was that there was no jurisdiction to grant a final injunction in the absence of service.
Well, if that is the proposition, I say that it's wrong, and I'll deal with that under my fifth point. But the primary response to it is that if one is working on a GAML basis, these are not injunctions granted in the absence of service. They are injunctions granted prior to service, undoubtedly, but they are not injunctions granted in the absence of service, and I will elaborate on that.
They're only served if somebody breaks them.
They are served if someone breaks them, but it is the service and the breaking which has the material consequences, and they are designed so that prior to someone breaking them, they will be aware of them with the opportunity to apply to the court.
So the injunctions for those who don't break them will be effective as a constraint without service?
My Lord, yes, exactly as in, for example, the case of the third party in the spy catcher case, as in the case of any ex parte injunction, and as in the case of pre-action injunctions, and as in the case of many freezing orders, for example.
So it's almost a species of ex parte injunction.
My Lord, I would not in any way dissent. I think from I think the way it was my Lord Briggs who formulated it in the course.
I'm not sure my Lord Reed didn't get there first, but never mind. This is not a competition.
No, indeed not. But I think the formulation from whoever it emanated was that this is, as these injunctions operate against newcomers, they are in substance a form of ex parte injunction.
However long after the proceedings have ended, if they're still in force.
However long after the injunction has been granted, right, if it is still in force. Yeah. And would we say the Master of the Rolls was right to say that the proceedings do not end so long as an injunction is live and in force. Yeah. Yes.
Quo ad, an individual, I mean, we have to work on the assumption that most law-abiding people in the country, once they know there's an injunction and that they're subject to it, will obey it. So that the moment to test whether there was any jurisdiction to impose that compulsion on them is at the point when they may be tempted to do something, but knowing there's an order that they mustn't, don't. And that person will never become a defendant.
My Lord is absolutely right to say that, well, first of all, that one must assume compliance, and indeed, did we not think that compliance was in practice likely, we'd hardly be bothering to seek the injunctions or to defend their availability. Secondly, it is therefore right that if the act of service is also the breach, a party who does not breach does not become a defendant by that means. But thirdly, it is also the case that the person who, as it were, steps back from going on the land or whatever it may be at the point at which they become aware of the injunction is at that point at liberty, usually under an express provision, but as the Court of Appeal rightly held, whether there is an express provision or not, to apply to the court to vary or discharge the injunction, which could, I would submit that a party can do that, just like a bank subject to a freezing order, without formally becoming a defendant. But if for some reason they see procedural advantage in becoming a defendant or necessity, they can apply to be joined as a defendant.
May I also understand your submission to go this far, that there may never be a defendant at all to these proceedings? Because if everyone complies in the manner you're describing and there is no named defendant, then there will never be a defendant to the proceedings, and they will simply be floating there as...
Well, Lord, that must logically be right, and I suppose that's also true in the case of a pre-action injunction. If the planned defendant, before the claim is actually issued,
well, if I might respectfully put this to you, that in the case of many of these without notice injunctions in the matter of intended proceedings, for example, that there is somebody in mind upon whom the proceedings will be served at some point.
Well, my lord, that is, of course, with respect, true, but there are people in mind when these injunctions are granted. They are not identified, and indeed at that point they are not specifically identifiable, but these are effectively precautionary, injunctions. Were there not a, what we call the test for shorthand, a strong anticipation that there will be such persons, the injunction would not be granted as a matter of clear and settled practice. So there are people in mind. It is theoretically possible, and perhaps if one assumes an entirely law-abiding world, perhaps it's a serious practical possibility that the act of service will not be and will not need to be perfected. But that must be, at least theoretically, the position in any case of a pre-claim injunction. Yeah, that is not clearly not treated as a bar of principle to the court having jurisdiction to proceed in that way. So, well, if it is right that Section 37 does confer jurisdiction in the strict sense, and in our printed case we've dealt at length with broad idea and so on, then the question in furry terms is whether there is some principle or settled practice which leads to the conclusion that it is always wrong to grant such an injunction, or to grant one on a final basis. We say that there clearly is, and has been since Bloomsbury, an established practice of granting newcomer injunctions in appropriate cases. My learned friend Mr. Drabble seeks to characterise the Court of Appeal's decision in this case as a new and radical extension to final injunctions, but in truth we submit the position is that prior to the fairly brief dicta in Canada Goose, which you've seen, no one had ever suggested that there was any vital distinction between interim and final orders for this purpose. And Lord, that takes me on to the second heading.
Could I just ask, Mr. Giffin, in the Bloomsbury case, it was an interim order, wasn't it?
My lord, it was, but when I come to Bloomsbury, I will seek to show you how insubstantial any distinction between an interim and a final injunction would have been on the facts of that case. And indeed it goes further, though this is to skip ahead of myself. If there was such a vital distinction, then as a matter of logic, it would have the results that for which the appellants argue, and for which Mr. Justice Nicklin accepted, that it would severely limit the purpose for and the circumstances in which interim injunctions could be granted. Otherwise, there would be the absurd anomaly that the court could go much further at the interim stage. So that is why Mr. Justice Nicklin says, and the appellants continue to contend on issue 2 before your lordships, that you can only grant the newcomer injunction on an interim basis if you're doing so for the purpose of, and in the expectation that, the persons unknown will be identified and served by the time you get to the trial of the claim for a final injunction. What I was seeking to demonstrate is that in Bloomsbury, in Ineos, there is no trace of any such reasoning in the grant of interim injunctions, and indeed, certainly in Ineos, it's demonstrably inconsistent with the actual grant of the injunction, but that is to go ahead of myself a little.
Yes, and you have to bear in mind that this court operates at a different level from the Court of Appeal.
Of course.
And where, you know, to some extent, I think we've emerged from the Court of Appeal's precedent-bound analysis, which may or may not have succeeded in fitting these orders within established categories onto, if you like, the sunlit uplands of legal principle, where this court can contemplate the possibility of a Wolverhampton order, if you like, as a genus which may not neatly fit the established categories.
My Lord, I respectfully follow the point your Lordship's make. I think unless your Lordship is positively discouraging me from doing so, I ought to try and address as it were, the established categories, but I entirely take your Lordship's point with respect.
Yes, we certainly need to understand the Master of the Rolls' approach, and we'll need to consider very carefully whether or not to follow it.
Well, yes.
Well, one of the problems is that words, even English words, not just Latin words, have unexpressed shades of meaning. And in this context, when using a word like final injunction, that may mean something actually different, not merely to anybody, but even to hard-thinking lawyers who spent all night worrying about it. Because finality to some may mean, after a proper opportunity for the person who is meant to be affected by it to appear, and they don't have to appear, but to appear and state their case. And final actually has that built into its very meaning. In which case, you can't, as a matter of very meaning, have a final injunction against a person unknown. At any rate, a law-abiding person unknown who doesn't breach the injunction. So I think we do need to be really careful when splashing around words like ex parte, all right, without notice, interim, final, as to just what we mean when we're saying that.
Yes, I mean, for example, an Anton Pillar order or a Norwich Pharmacal order is, in one sense, final. You execute it. And its execution will involve an interference with people's rights.
Yes.
And that is typically done ex parte and before service. But is nonetheless a valid form of order.
Lord, absolutely. And I mean, if I can perhaps just try and step back for a moment, precisely because of the dangers of it becoming a debate about words. In my submission, this is rightly seen, and to this extent, I think, common ground between all the parties to this appeal. This is fundamentally an issue about natural justice, procedural fairness. That is how it is expressed in Cameron. It is how the appellants put their case in support of there being relevant limiting principles upon the exercise of Section 37 powers. And that is why our fundamental point, which I hope I shall be able to make good by reference to authority, is that there is nothing intrinsically inconsistent with natural justice or procedural fairness in the grant of an injunction which has an impact on people before those people have had an opportunity to engage with the court about it, to try and strip it of as much technical language as possible. So that is really, in my submission, at the heart of what your Lordship, if your Lordships are satisfied that these matters can be dealt with in a procedurally fair way, and we're not talking about how any particular injunction was or wasn't granted. If your Lordships are satisfied that these matters can be dealt with in a procedurally fair way, then the appeal in my submission should be dismissed.
Well, it's not just procedural fairness. The other point that's been made is that there needs to be a proper proportionality assessment before the order is made.
With respect, your Lordship's absolutely right. Certainly in the cases where convention rights are engaged, which will include some of these cases. Yes, absolutely. Yes,
Which they will, yes.
Yes, absolutely. So,
Which incidentally probably has to be undertaken in relation to an Anton Pillar order, just as it does in relation to one of these.
Absolutely.
Now.
oh yes, Very much so, yes.
Probably not when Anton Pillow was originally conceived.
Pass. Yes. So, so on my second heading, the question of whether a newcomer injunction is intrinsically incompatible with principles of natural justice, that's said to follow from Cameron. I think I do need to deal with Cameron because whilst clearly issues of this kind are not part of the ratio of Cameron one way or another, nonetheless, your lordships are not entirely on the sunlit uplands when it comes to previous authority of this court. And my learned friend Miss Harrison put her case this way. She said that orders binding a non-party subvert the fundamental principles of the adversarial process in a way that goes to the heart of the court's jurisdiction, and she said that there was a right to be heard before orders are made which curtail freedom. But Cameron is at page 2202 in your lordship's bundle. Because it's been read extensively, I will go straight to the specific points I want to make. Paragraph 9 at page 2208 asserts the general rule that proceedings may not be brought against unnamed parties. Paragraph 11, it's at page 2210, letter C, refers to a line of precautionary injunction cases when the defendants could only be identified as persons who might in future commit the relevant acts. And although Lord Sumption then goes on to say that the Supreme Court is considering the jurisdiction for the first time, there is nothing in his judgment to suggest he regarded any of those cases as wrongly decided, and indeed, as was noted in Ineos, Cameron paragraph 15, page 2211 to 2212, amounts to express approval of Bloomsbury and Gamble and no disapproval of Ineos at first instance, Hampshire Waste, or indeed any other existing newcomer injunction case. And when one looks at Lord Sumption's two categories in his paragraph 13 on page 2210, the entire point in my submission, spelled out in fact at paragraph 16, the point about the second category is that it is conceptually impossible ever to identify that people in that second category so that they can be served and participate, because you will never know who that unidentified driver was. And the reason why that matters is clearly for natural justice reasons, that as one sees from paragraphs 17 and 18 of Lord Sumption's judgment. But, now, newcomers, of course, at the time when the injunction is granted, are a third category, they don't answer either of the two category descriptions, but the whole point in my submission is that their future actions will, if of the specified kind, put them into the first category. And that is the first sentence of Lord Sumption's paragraph 15. And we'll go just following paragraph 15 over the page, picking up 5 lines down, his lordship says, where an interim injunction is granted and can be specifically enforced against some party or by notice to third parties who would necessarily
property. So I think you said party.
Property. Against some property or by notice to third parties who would necessarily be involved in any contempt. The process of enforcing it will sometimes be enough to bring the proceedings to the defendant's attention. And he gives the example of Bloomsbury and the unnamed defendants having to identify themselves by, if they sought to do the prohibited act. And he refers to Gamble And it says in the last sentence, in the case of anonymous but identifiable defendants, these procedures for service are now well established and there is no reason to doubt their juridical basis. And then a key sentence, one does not, however, identify an unknown person simply by referring to something he has done in the past, i.e. the road traffic accident in Cameron. And further down the paragraph, Lord Sumption says, the problem is conceptual and not just practical. And the conceptual problem in that case was that there was no way in which the unknown driver would ever be anything other than unknown. In other words, that defendant's driver was just a cipher or a device to get round the fact that, as Lord Sumption says earlier in the judgment, the English statutory scheme allowed no direct claim by the victim against the insurer. But the critical words are, one does not identify an unknown person simply by referring to something that he's done in the past. And this is why injunctions are different from a damages claim, such as dealt with in Cameron, because it is the very nature of an injunction that it only affects people by reference to what they will or may do in the future. And therefore, if future conduct in relation to the injunction is the identifying act, and as Lord Sumption says, emphasises in Cameron, if you're going to have alternative service, it must be by means likely to bring it to the attention of the person concerned, then the problem identified on the facts of Cameron does not exist. Now, I'm conscious, of course, that Lord Sumption uses the word interim on a number of occasions in these paragraphs, but and where he uses it, that's an accurate description of the injunctions in the cases to which he's referring. But as a matter of logic, Lord Sumption's proposition that what matters is the future act which leads to identification and thus to effective participation in the proceedings must apply in exactly the same way in the case of a final injunction as it does in the case of an interim injunction.
The difference may be the stage which the proceedings have already reached, and that may explain the paradox that you referred to earlier of this principle, this Bloomsbury extension, operating in a way in which it cannot operate, operating in interim order in a way in which it cannot operate in relation to a final order.
Yes, well, the paradox would exist, or potentially exist, if one took the view that the two situations were fundamentally different. And this is Mr. Drabble's position, of course, when he says to your lordships, as he did yesterday, that the position has fundamentally changed by the time you get to the final stage, because he says that subject to the liberty to apply, and of course my submission is that's a very big, indeed a massive subject to, but subject to the liberty to apply, an order has been made that affects people's rights or infringes upon their freedom to act in a particular way. But if we are talking about procedural fairness and natural justice, we should be focusing, in my submission, upon substance and not upon form, and as a matter of substance, what is different at the final stage, if we take the final stage to be the point at which the court has either conducted a trial or has determined there is no need for a trial, e.g. because it gives summary judgment. In other words, it is final in the sense that the court is not anticipating some further step in the procedure with its existing ruling simply a staging post on the way to that. What has changed? The impact on rights is no different with an interim injunction or a final injunction. Indeed, the examples of the Anton Pillett, the search order, and indeed freezing orders, many interim injunctions have including ex parte injunctions, have a huge effect.
Well, of course they do, but after the final hearing, there has been a determination of the merits of the claim, and an injunction is granted, and clearly for anybody to come along thereafter and make an application to have the injunction varied is going to be quite an uphill task. But at the interim stage, it's much more a question of preservation. One's holding the ring in most of the injunction cases without any determination of the merits of the claim beyond that which is necessary to satisfy the court it is appropriate to make a protective order.
Well, may I address that in two stages? And first of all, may I respectfully take issue with your lordship's proposition, at any rate if expressed as a sort of general proposition or universal one, that it's going to be an uphill task to persuade a court to vary a final injunction. My submission, that will depend very much on the circumstances in which a final injunction has been granted. For example...
Well, I beg your pardon, then it may come back to a question of terminology, because when one is discussing the notion of varying a final injunction, one is effectively saying, well, now there are parties before the court. The court will look at this question as an original matter and decide whether or not a protective order is justified, either indefinitely or for a limited period of time. Then, in a sense, it isn't a final order at all. And one's back to that question of terminology. When I put my question to you, I had in mind a final order in a conventional sense after there had been a determination of the merits of the claim.
Maud, then if it is final in the sense that there has been a final determination of the merits of the claim as between parties who have been represented or have had the opportunity to be represented before the court, then what my lord says is, with respect, undoubtedly correct. It will then usually be, absent some change in circumstances, a difficult task. On the other hand, suppose the case where there are one of these injunctions, perhaps where there are no named defendants, and the matter has proceeded to a non-interlocutory grant of an injunction without anyone being heard. Then in my submission, I mean, obviously the court will do its best to anticipate arguments, but in my submission, if someone then turns up and says, well, you haven't heard argument on this, do you realise that there's this other statutory power, or that there are no transit sites, or whatever it might be in whatever context, or that I have particular circumstances that bear very hardly upon, then there is no a priori, of that bit of Latin, reason to assume that they will have an uphill struggle. But even that, as I understand it, is certainly the type of case in which learned from Mr. Drabble would class as a final injunction and would say that it is impermissible in principle for the court to grant a newcomer injunction. And indeed, it is at the heart of the vice of the appellant's submissions, if I can put it that way, is that contrary to all the guidance in broad idea, it is based upon a rigid categorisation which is unresponsive to these potential factual nuances and the existence of the spectrum, procedural and factual spectrum on which these cases may fall.
Well, Mr. Giffin, if it's necessary to have regard to the substance, not the form of the final order,
yes,
as you submit, then is it not necessary also to take account of the likelihood of a traveller arriving at an encampment and finding a notice on a post, actually making an application to the court under the power to apply?
Well, the answer is, Lord, that if a court is considering whether to grant an injunction, that may be relevant. Many things may be relevant. The court ought to be concerned when it grants an injunction against people not yet before it to ensure, to the extent it considers appropriate, that they have a realistic opportunity to apply to set it aside. Lord, I would have to submit that some of the points raised by my learned friend Mr. Drabble and by some of the interveners go perhaps to the difficulty of some parties, particularly individual parties, participating in litigation at all.
Even if they have been served.
Precisely. And you know, those are not trivial concerns. I do not seek to trivialise them, but query how much they really have to do with this case with respect.
I might put one other point to you in this context, which is that certainly it was my recollection in the original days of the search and seize orders that where they required people to disclose information which might incriminate them, in those early orders, they had to give the information even if it would incriminate them, and that ultimately became a reason to circumscribe the orders themselves and, in due course, to introduce legislation which meant that they couldn't effectively incriminate themselves because the evidence couldn't be used against them in criminal proceedings.
Yes, well, that's right. There was the one built the proviso into the asset disclosure aspect of the freezing order or into the Anton Pillar. You didn't have to disclose, and then it was whichever act it was that introduced the proviso, I think first for intellectual property cases and then subsequently more.
But it may be an illustration of the point my Lord has put to you about the danger of simply sweeping these away as being practical difficulties, because that was a fundamental problem with the original search and seize orders, which only came to light in time and required legislation to address it.
Well, yes, I mean, the legislation was required, I suppose, in order to enable there to continue to be effective orders. And the problem was addressed initially by the terms in which orders were granted. And I don't seek to suggest that there are not and will not be, significant practical issues in working out how newcomer injunctions ought to be dealt with. And I hope I'm not just trying to duck the question by saying it's all a matter of practicality and working out. It is the nature of the appellant's case, not our case, that there is an in-principle bar to these injunctions ever being granted. This is not a battleground of our choosing. There are, well, I don't know what more I can say about it than that. We entirely accept, and I want to show your lordship, and perhaps leave Mr. Anderson also to show your lordship, some examples of courts doing their best to work these things out. And if your lordship say, in principle, these are always wrong, then of course that process will come to a halt. But if your lordships give the contrary answer, then it will continue. And the world of travel injunctions, for example, is very different after Bromley than before Bromley, even though Bromley has not much directly to do with this newcomer issue. So, Lord, I hope when I say it is a matter of practicality and whether injunctions should be granted on particular facts and in what terms, that's not ducking the issue. Rather, it is addressing the issue which this court has to decide.
Mr. Giffen, at the risk of taking you even longer to get back onto course, can I just test your submission that if you read paragraphs 15 and 16 of Cameron,
Yes.
it provides a juridical justification as much for final orders as it does for interim orders?
Yes.
Correct me if I'm wrong, but the way I read paragraph 15, particularly in the reference to Gamel, where Lord Sumption must have known it was an interim injunction, is that it works juridically in relation to persons who do put their head above the parapet by doing what the order prohibits and therefore become defendants and liable to a process of service that will get to them. It does the trick for final orders only in relation to those persons, i.e. persons who, even if they haven't said what their name is, have become identifiable by doing something which the order prohibits. I don't think at the moment, but I'm interested to see whether you want to persuade me to the contrary view, that there's anything in that analysis which makes the final order work juridically against someone who at the interim stage doesn't put their head above the parapet and therefore doesn't identify themselves in a way that makes them a defendant or expose them therefore to the well-recognised procedures for service which would run their course before any final order is made against them.
My Lord, it is different juridically. It really goes back to, I think, the question my Lord was putting to me slightly earlier, that people may not become defendants by that route. But my answer remains that if one is concerned with the procedural fairness, the natural justice of the proceedings, then what matters is that the party should have an opportunity to persuade the court that the injunction should no longer bear upon them.
And you say that's dealt with by liberty to apply.
It's dealt with by liberty to apply. And in a sense, I suppose that is, in procedural terms, a different juridical route, but it achieves exactly the same result in natural justice terms.
Sorry.
I was going to put one other point to you, and that is that is it possible, at least to some extent, to ameliorate the difficulty by requiring a claimant to mount a much stronger case when making the initial application as to the merits of their claim if they're going to secure one of these orders? So the court doesn't look to see whether or not there is simply a case which in normal circumstances would, the judge thinks would be adequate to go to trial, raise an issue to be tried, but the judge needs to be satisfied of the merits of the claim to a much higher level.
My Lord, can I answer this way? The test for granting precautionary relief, as set out in INEOS and slightly modified in Quadrilla, is already quite a high test. It's quite stringent. It has also already been said that courts ought to be cautious about granting newcomer injunctions. That is the substance of what the Master of the Rolls said in this case, and I'd have to check the reference. There's certainly other cases to that effect. I would be, with respect, a little reluctant to invite your lordships to lay down some rigid principle of the kind, you know, perhaps one use some aspects of service out of the jurisdiction under the old law where there is some specified standard of proof or whatever the appropriate phrase might be. But certainly, I wouldn't in any way resist the proposition that if the court is taking the exceptional step, and I say exceptional in the sense that it's not the norm, as opposed to whether it's numerically exceptional or not, if the court is taking the exceptional step of granting injunctive ex parte relief against people who have not had an opportunity to be heard, yes, it should be cautious and it should require good evidence. Now, exactly how good that ought to be might depend on, you know, is this injunction being granted for a 2-month period, or is it being granted for a 2-year period? How likely is it, to go back to the point Noel put earlier, that it will be a practically viable proposition for people to come and apply to vary and discharge? It might depend on what the court at that stage understands as being the extent of the trammelling of people's liberty. I mean, it may be that the case about running on unlicensed commercial punting operations in Cambridge is different on the spectrum, in a different place on the spectrum, from traveller cases involving family life. I'm sorry, I'm failing to stay within the mic.
Sorry about that.
I'm very sorry.
No
and so forth. So it may vary. But in principle, I don't in any way resist the proposition that the court is doing something outside the norm and should be properly satisfied that it's really necessary to do so. And this is not unconnected with one of the other points Lord Reid put to me, which is the relationship where there are schemes of criminal legislation. It is already well established, both in these newcomer cases and in other cases, that where there is such a scheme, resort to an injunction should be the last resort. The claimant should need to demonstrate that other means of enforcing are not satisfactory. The most, just for the note, without turning it up, the most recent formulation, I think, or the most recent summary on that score is in the case of Sharif, which I've just written down, tab 97, so I will have to get someone to give me a page number to give to your lordships, but it's in the bundles.
And is it
4226, I'm told.
Is it part and parcel of that regardless at what procedural stage you're seeking the injunction, either ex parte right at the start, inter partes but still interim on a return day, or final, using final only in the sense of the so-called trial, for example, against named defendants, that quoad unnamed defendants, or at any rate newcomers, the applicant remains throughout and at all those stages under a very strict form of the golden rule, that's the ex parte Polignac rule, to make full disclosure of relevant facts, including those things which the applicant thinks that the absent newcomer might want the court to think about before making the order.
Well, my God, I think that must, with respect, that must be right.
Yes, because I mean, I anticipate that people often think, well, there's no continuing ex parte duty once we've got past the ex parte stage, but it will always be ex parte against an unnamed defendant, an unnamed person, a newcomer. If that person is a newcomer at the date when a quotes final, quotes off order is made, then as against him, it's still ex parte.
My Lord, with respect, I think that must be right. I mean, again, there is some scope for nuance. I mean, one does sometimes have cases where there are a large number of named defendants, some of whom participate, but you also have unknown persons named. I mean, there may be cases in which, generally speaking, one imagines that those who are named and before the court will have made the points, but in principle I accept what your lordship says, and indeed it may be the Court of Appeal in this case indicates that such injunctions should normally be time limited, and depending on the subject matter, it may be right that these injunctions should normally build in a review provision, as, for example, the Wolverhampton one did. Now, one does have to bear in mind there's a wide range of subject matter. Your lordships have probably seen that there is a permanent injunction, a final, permanent, indefinite newcomer injunction in place to stop people climbing the Shard from the outside. Pretty obvious why that has to be granted on a person's unknown basis. By the time you know someone's halfway up the Shard, it's a little difficult either to identify them or seek an injunction against them. And it may be thought that, in truth, reviewing that from time to time isn't going much to change the nature of what has to be thought about. But in other cases, so one ought to resist absolute rules because there is such a diversity of facts. But in principle, I accept what my lord says. Yes.
I think the discussion we've been having, I think, rather demonstrates why it's not illogical that the inability to identify a defendant may be less important at the interim stage than it is at the final stage. And at the interim stage, the court is generally concerned to preserve the status quo, whether it's by an injunction or an ante-pillar order, which is preserving evidence, essentially, or a freezing order, which is preserving the availability of assets to satisfy an order. Whereas at the stage of making a final order, the court is actually adjudicating authoritatively on the party's rights. And you can see why, whether you view it from the point of view of natural justice or not, you can see why the inability to identify the defendant is a matter of less fundamental importance at the earlier stage than it is at the latter stage.
Lord, in the terms in which your lordship puts that proposition to me, I absolutely agree with it. May be of less fundamental importance, all of which words I apprehend my lord uses advisedly, and to indicate that the fact that one is no longer at an interim stage may be an important, maybe a significant factor. But that's not learning from Mr. Drabble's case. His case is that there is a rigid 100% absolute conceptual difference, and that is what I resist. There may be some respects in which it is easier to justify the newcomer injunction at the final stage, because if you've had a final hearing with all the, particularly perhaps if you've had some named defendant there as well, it may be absolutely clear that the claimant's rights are being infringed, that there is no other practical way of stopping the infringement, and that there is no human rights or other justification for not granting the claimant the effective remedy that he needs. So it might then become actually much easier to say, yes, definitely final injunction. But may is the critical word. One ought not to be ruling things in or out in the abstract in advance.
Yeah. Well, I can see, for example, in a case like Bloomsbury, where most of the defendants had actually been identified. If that case went to trial, there would be the possibility of there being a full adversarial hearing by involving people whose interest was exactly the same as the unidentified defendants who were not present.
Yes, I mean, maybe I can make the point I was going to make about Bloomsbury without turning it up, because the facts are neither not terribly complex and are quite well known. The people started approaching commercial outlets with bootleg copies of the book a couple of months before it was due to be published. Interim injunctions were granted on a couple of occasions on a short-term basis. And then, in the decision of which we have in the report, an injunction, still interim, was granted up to and including the publication date. Now, it is plain that there were, and it was at that point, I think, still about 3 weeks before publication, something of that order. It is plain there was never going to be a trial after that interim injunction had been granted, not on an injunction anyway. Other forms of relief may be another story. But just suppose Mr. Drabble were right, and suppose the Vice-Chancellor had said to counsel in the case, I'll grant this interim injunction, but this doesn't seem a terribly complex matter. My case for next week is settled. We will have the trial next Wednesday. According to Mr. Drabble, if counsel for the claimant, I think the Lord, had persuaded the court that it could be finally satisfied with the cause of action and that all the elements were there to make an order against newcomers, that would have been a spectacular act of self-shooting in the foot, because, according to Mr. Drabble, that's precisely the point at which it would have ceased to be possible to have the injunction. And by the same token, one sees no consideration in Bloomsbury of the only purpose for which Mr. Drabble says you can legitimately grant an interim newcomer injunction, which is to enable the unknown persons to be identified before the trial. I don't know whether it was remotely likely in practice that they could have been, doesn't seem terribly likely, but certainly there's no indication either there or in INEOS or in any other interim and newcomer injunction case that we have in the bundles, as far as I can see, of the court concerning itself in the slightest with the question of, are these people going to become identifiable before the trial? Well, that perhaps, well, I'm conscious now 11:35, that may be when a suitable...
This is a convenient moment for you, Mr. Giffen.
Yes, I'm probably running a little behind, but as we break, I'll try and reduce what I now need to go to.
Well, we'll try to restrain ourselves. It's a very interesting case.
Not undermining the right of the person affected to seek rapid relief. Nothing in our judgment can be made of the fact that under Rule 6 it's for the parties, not for the court, to seek a review. Because an application for an interim order without notice can only be made when the Justice's clerk is satisfied that it's necessary for the application to be made without notice, and because the order can only be made for a limited period when the court considers it's just to make it, and in circumstances where it can be reviewed or discharged as indicated above, it seems to us to be impossible to say, well, to impossibly say it determines civil rights. Certainly for a time it restricts certain freedoms, and the restriction can be enforced by sanctions, but that is the nature of any interim order. So in our judgment, provided the interim order follows its normal course, Article 6 will not be engaged. Then 6, although Article 6 is not engaged, the procedure must be fair, and there is no apparent unfairness in the procedure we have had to examine. and if Article 6 were engaged, it would be appropriate to look at the process as a whole, and I'm not sure I need the rest of it. So obviously it ultimately turns on the particular procedures, the particular statutory scheme, but Lord, in my submission, if the Court of Appeal was right in that case, it is very hard to say that the kind of injunctions we are dealing with here are conceptually, inherently, procedurally unfair. The other case I wanted to show the Court was A and the BBC, which is at page 2573. Lord, this is a case about an anonymity order made in deportation proceedings, and the issue then that the media wished to identify the individual. Lord Reid gave the single judgment which deals with a number of issues. I ask your lordships perhaps to note in passing that at pages 2594 to 2595 there's a discussion about the common law and the convention going hand in hand in terms of the court's powers. And then at page 2596, my lord set out section 12 of the Human Rights Act, concluded at paragraph 66 that didn't strictly apply in circumstances of the present case. But then paragraph 67, the Lord President observed that even if the media were not entitled to be heard by virtue of section 12.2 of the HRA, they were entitled to be heard as a matter of fairness, although there was a question as to the stage at which the opportunity to be heard should be given. I agree. There are many situations in which courts make orders without having heard the persons who may be affected by them, usually because it's impractical, for one reason or another, to afford a hearing to those persons in advance of the making of the order. In such circumstances, fairness is secured by enabling any person affected to seek the recall of the order promptly at a hearing inter partes, and further down the paragraph, my lord also expressed the view that that satisfied Article 13 effective remedy requirements. And clearly the factual context is different, but in my submission, that statement of principle is as good in our circumstances as it was in A and the BBC itself. Lord, I think I've now covered, in effect, my second and third headings together. So let me go straight on to the fourth heading, which is the is convention rights, the proportionality problem. Lord, sometimes, depending on the nature of the injunction in question, convention rights of newcomers will be engaged, sometimes not, sometimes strongly engaged, sometimes weakly so. In protester cases, Article 10 and Article 11 will usually be relevant. In traveller cases, well, sometimes Article 8 may not be engaged at all if there is no home yet established and if the particular injunction does not trammel upon the ability to pursue the travelling way of life, which is a facet of Article 8, but in some cases, Article 8 rights certainly will be engaged. So, as a matter of principle, one needs to work simply on the basis that convention rights of newcomers may be in play, and that the strength, or the prima facie strength of those rights may vary from case to case. We say that this is all fact sensitive. Sometimes those convention rights will be being balanced against common law rights, such as the right of ownership of land. Sometimes they will be being balanced against other convention rights, such as the Article 8 rights of people who, perhaps whose life is being, who live nearby and whose life is being made miserable by whatever the activity is. But this is all fact sensitive, and our objection to Mr. Justice Nicklin on what is now issue 3 before your lordships was that he simply said in the abstract that there could never be a convention justification for granting a newcomer injunction in an encampment case, fundamentally. But we say the answer to that is it all depends. Now, the reliance on convention rights the other way is my learned friend Mr. Bunting's point. The suggestion that the court cannot do the necessary proportionality exercise if the newcomers, by definition, are not before the court. But that, with respect, we say is wrong for this reason. A court must always consider whether an injunction granted on an ex parte basis is a proportionate measure. And that includes, in particular, it's probably not limited to, considering proportionality in the context of any convention rights that are engaged or likely to be engaged. The court does that on the basis of the material which it has at the time at which it is dealing with the matter. If the court is granting or being asked to grant an injunction in general terms, i.e. against a class of persons as yet unknown, then what it has to do at that initial stage is to consider the likely impacts on convention rights and the balancing of rights at a general level. If subsequently, if either then or subsequently a particular person is before the court, including, for example, when asking for discharge of or variation of an injunction that has already been granted, then, of course, any particular individual circumstances or relied upon which are relevant to proportionality may also come into play and be considered under the rubric of proportionality at that stage. But it is a misconception in my submission to say that the court cannot properly consider proportionality just because it does not know all the individual circumstances of someone not yet before the court, any more than the court can't grant an injunction which may have spy-catcher consequences for third parties because it doesn't yet know who the third parties are or exactly how they may be affected. Lord, in our submission, that's really ultimately a matter of common sense, but if one needs confirmation, it is to be found in the case of Attorney General and Punch, which the court has at page 2638 in the authorities.
(268) or
2638, I'm sorry.
I thought it looked rather a low number.
And this is a case involving spy-catcher type contempt, and it is mainly a case about what the necessary mens rea is for that form of contempt. But the passage with which I'm concerned is in Lord Hope's speech, and it starts at, it's the section headed, starting at page 2665, headed the wording of the injunctions, and without reading it out, Lord Phillips in the Court of Appeal had expressed concerns about the effect of the injunction and spycatcher being that no newspaper could knowingly publish any matter that fell within the wide terms of the injunction, and it had been granted in fairly wide terms because it was difficult to formulate with precision what would or wouldn't affect the relevant national security interests. Now, at page 2666 over the page, para 113, Lord Hope recognises that convention right of free speech is engaged, and at 114 he says the word necessary in Article 10.2 raises the question of proportionality. But in my opinion, there can be no objection to an interim injunction against the publication of information on the ground of proportionality if three requirements are satisfied, and then picking it up at F. 1, there's a genuine dispute whether the information is confidential. 2, there are reasonable grounds for thinking publication before trial would impede or interfere with the administration of justice. And most materially, 3, that the interference with the right of free speech is no greater than is necessary. And it's this, and then close attention to the facts is needed when consideration is given to the question whether the protection is necessary. And then picking up again at para 116, any formalities, conditions, restrictions or penalties, i.e. the injunction or equivalent, to be permitted by Article 10.2 must satisfy the principle of proportionality. In summary, they must be sensitive to the facts of the case, they must be rational, fair and not arbitrary, and they must impair the fundamental right no more than is necessary. In my opinion, these tests must be satisfied at every stage in the judicial process that is liable to affect the exercise of the fundamental right. This includes the stage when the court is deciding whether or not to make an interlocutory injunction, and if so, in what terms, and it also includes the stage when the court is considering whether the order should be varied following an application for that purpose by any third party before the trial. In other words, as I've submitted, this is a continuing process, and manifestly the nature of the exercise depends on who is currently before the court and what they're saying. And the very fact that an injunction is being granted with an opportunity for someone to come along and seek to have it varied or discharged is relevant to proportionality. We see that from paragraphs 122 and 123 on 2668. Above all, full weight must be given to the purpose of these injunctions. They're interlocutory injunctions. It was not the intention when they were granted that they should be permanent. And I pick it up just above the foot of the page. The court remains available to give its own judgment before the trial as to whether publication of the material in the meantime would be objectionable, having regard to the purpose of the order and the requirements of the principle of proportionality. So I don't think that the terms of the injunctions can be regarded as disproportionate in view of this safeguard, i.e., in effect, liberty to apply. And then picking it up just below B, the requirement of proportionality is satisfied, 1, because the opening words of the order are qualified by the first proviso, that was a provision for Attorney General consent, 2, because the extent of the injunction remains subject to the further order of the court, and 3, because the court itself must observe the principle of proportionality when it deals with any application before the trial for relaxation of the scope of the injunction, and would so too in our context. And in my submission, that is actually exactly what the Master of the Rolls was saying in this case at paragraph 105 of his judgment, page 453. He wasn't saying you don't worry about proportionality when you first grant the newcomer injunction. If one reads that paragraph properly, he's simply saying, well, you can't. It's not an exercise at that point in thinking about individual circumstances. That point comes at the point when anyone raises them. My Lord, given that I'm running or have run out of time, I'm not going to take, my Lords, to the examples, but I am going to tell my Lords what they are, and perhaps ask that if you have an opportunity to look at them, you might do so. And the three I would mention are, first of all, the Hillingdon case at page 5347 in the bundle of authorities. This is an interim injunction that doesn't matter for this purpose, where in my submission at paragraphs 95 to 122, the court will see Mr. Justice Carr carrying out what I respectfully characterise as a careful and impeccable consideration of proportionality in the case of a newcomer injunction before the court. My second example is the Cambridge punting case, page 2797, again interim, but particularly relevant in the light of some of the court's questions and comments at pages 2809 to 2815 about use injunctive relief as a last resort where there are other possible statutory or other remedies available. And on page 2814, I've lost the particular subparagraph, but there is a paragraph which explains why, in specifically, a person's unknown injunction is needed, because otherwise new corporate entities or new punt touts just pop up all the time, and you either give up or have to keep going back for more injunctions. It's the, if my lords have ever played the relevant fairground game, it's the bash the rat problem. You don't know where it's going to pop up next. Lord, the third example is at page 2713, the case of Nagmadeen, which is a very recent further decision in the car cruising problem context. I'm sorry, 2713.
Thank you.
Which is, in my submission, I'm not sure whether Mr. Anderson may not say more about this, a striking example of a very pressing social problem where it's hard to see how it would be tackled without an injunction of this kind, and where one sees how carefully the court thinks about ways of bringing the injunction to people's attention. So,
are there any particular bits of that one by way of shortcuts to Scott?
it's fairly short, but it's really near the start. Let me just try and...
No, don't worry. I mean, if you just say read it all, we'll read it all.
Yes. Can I say to my lords, paragraphs 5, 13 to 16, setting out the impact which Mr. Justice Nicklin's decision and then the Court of Appeal had. Paragraph 34 to 37 on means of alternative service. 49 to 54 is more about alternative statutory remedies and being satisfied you really need an injunction. And paragraphs 59 to 60 is proportionality, although that had largely been considered in other previous rounds of the process. One of the questions which Lord Reid asked me at the start that the respondent should deal with, and really comes under my fifth heading, is suppose GAML doesn't work, is there a way through? Well, in my submission there is. I'll take this fairly shortly, but if one looks at the high watermark of the Appellants case, apart from Cameron, it's Spycatcher at page 2072, where it is said that injunctions operate inter partes and should be so expressed. But that is expressed as a general rule. We know that there are exceptions to that general rule. because we know about Venables and so on. In my submission, for reasons we've given in the printed case, in which the court discussed with Mr. Drabble yesterday, a jurisprudential analysis of Venables, which says that it's all about convention rights, is not satisfactory. If one says it's that and no more, is Mr. Drabble, I think, ultimately was more or less constrained to accept that if the convention disappeared from our law tomorrow, the court would not regard itself as powerless where there was a sufficiently compelling justification to depart from the normal approach. And in the end, in my submission, it is section 37. It is broad idea and not fettering the court's ability to provide an effective remedy in cases that require it. But I think it's not just simply because of the time that I say ultimately, that is what it is, yes. So far, the courts have not needed to go down that more generally expressed road because the GAML mechanism approved in Cameron has been seen as a way to get there. But if that route, for some reason, is regarded as jurisprudentially defective, then the consequence should not be that the court finds itself powerless to deal with the car cruising problem and these other problems in the various cases. Now, what else did my lord ask me to cover before I sit down? Compelling justification, I think I've dealt with really in the course of my submissions. It's statutory scheme. I have either taken your lordships to or given your lordship the reference for the authorities that show this is a consideration. I would mention that in the guidance that my friend Mr. Drabble has helpfully handed up, you will find at in the circular at page 9, the guidance itself contemplates that.
Is this the 2015 guidance that we spoke of yesterday?
Oh, yes. Perhaps it hasn't actually reached you.
I don't know if it's been handed up yet.
Well, I think we've had it.
If it hasn't been handed, it's imminent.
Oh, it's in electronic form?
Yes.
Yes, we provided it both electronically
Yes.
and copies provided in hard copies. We have the hard copies if any member of the court wants it. But
Oh yes, I have it. I have it here in the supplemental bundle.
Yeah.
Yes.
And ultimately, of course, it's not legally authoritative, but it does contemplate at page 9 that in appropriate cases, despite the statutory powers, injunctions might be appropriate, or what it calls preemptive injunctions. Clean hands. Can an authority get an injunction in a traveller case if it's in breach of its own duties? The answer would probably be that it is a relevant factor to be taken into account. It's not an absolute bar. The court would, and indeed in the traveller cases like Wolverhampton, the court looks carefully at things like the availability of transit sites. What has the authority done to make them available? And I think there's probably elements of that in Bromley as well. On the other hand, the court would also look at for whose benefit is this injunction really being sought. If it was the authority's own benefit in some sense, then clean hands might be really quite a compelling factor. But if it's about stopping life being made an absolute misery for nearby residents, the court might think that the local authority's non-performance of statutory duties weighed less heavily in the balance. It would all be a matter for the assessment of the judge dealing with the case in my submission. And practical issues, duration. Again, perhaps I'll leave Mr. Anderson to show you how Wolverhampton worked. It's been said both in INEOS, in the protester context, and in, I think, by the Master of the Rolls in this case, that injunctions should be time limited. Issues about costs, well, the court does have powers to make costs orders even outside, preemptive costs orders even outside the public law sphere, I think. Certainly in this case, just as a for instance, it was readily agreed by every single local authority involved that they wouldn't seek costs against when in front of Mr. Willer's various clients at various levels. But courts can impose conditions, particularly on parties seeking the exercise of the court's discretion, as a party seeking an injunction does, just like when a party is seeking permission to appeal. Sometimes the court says, not if you want to be able to seek costs from the other side. So, I mean, a court would have to consider carefully whether costs issues were really related to the newcomer aspect of it and what was appropriate in the light of that. There'd be all kinds of fact-sensitive issues. Are there organisations which might take up the cudgels? Should they be, on what terms should they be expected to do so? But I certainly don't submit it's outside the scope of what can be considered. And, my Lord, I hope I've managed to cover most of the points raised with me at the start. I've already gone over my limits, so unless... I haven't? No, you've got 10 minutes. Oh, I've got 10 minutes. I thought I had to... I thought I was 20 minutes over. Well, I'm not now sure what to do.
Well, I think it's a matter between
10 minutes.
Between yourself and your colleagues. So, the court has given the three of you until sometime this afternoon. So.
Yes. I think, my Lords, my first question is whether there is anything I have not yet dealt with that my Lords wanted me to deal with, and otherwise I will use the time just to show my Lords one or two of the example cases I mentioned, and also one thing I cut out for time reasons was the case of Crédit Agricole, which is an interesting discussion of Cameron in a context of declarations. But unless any of your Lordships has a more pressing...
No, I'd certainly welcome something about declarations, because they have a contra mundum effect, or can have.
Yes. Well, Crédit Agricole is somewhere. It is at page 3467. It's a decision, Mr. Justice Morgan, and the
page again, Mr. Gibbs.
Oh, sorry, 3467, Lord.
Thank you. Yes.
Bank was in possession of a large number of items deposited between 1990 and 94 in safety deposit boxes. They hadn't been accessed for many years. Bank was unable to trace the depositors or representatives of their estates or anyone else interested in the items they contained. Banks wanted to sell such items as were saleable and were not collected by their owners. Lord, because of the commencement date of the Torts Interference with Goods Act 1977, it mattered whether the deposit was before or after 1st Jan 78. After that date, there was a statutory procedure for disposal. Before that date, there wasn't, so simply the law of bailment. But in both cases, there was a question as to how one could either invoke the statutory procedure, which I think required a court order, or get a declaration for the purposes of the law of bailment if you didn't know, if the bank didn't know and couldn't find the people with an interest in the safety deposit boxes. So, just before the held, the question arose whether the bank could bring proceedings under the 77 Act or at common law, or could apply for an order for inspection of the deposit boxes with a view to bringing such proceedings where the identity of the bailor or anyone else with a possible claim to the items was unknown. And the learned judge was very conscious of Cameron, as we see from paragraph 19 on page 3472. He says, in relation to cases covered by the Act, that since there is a statutory procedure, the court must be impliedly entitled to devise a way of making it work. And just above letter H on 3472, he notes that Lord Sumption went on to say the courts have themselves made exceptions to the requirement that a defendant be named in a claim form. And just below the foot of the page, it's consistent with Cameron to hold it's open to a claimant to issue a Part 8 claim without joining a defendant in some cases which are not dealt with by specific practice direction. Now, so the problem then, he then moves on to deal with the pre-78 Act boxes. Paragraph 25 at the foot of 3473. There's an important difference, to my mind, between the court granting a declaration and the court exercising a power vested in the court to authorise a sale. If there's no defendant to the proceedings and the court authorises a sale, then the bank can act on that authority. The sale will be a lawful act by the bank, and the owner of the goods cannot later bring a claim against the bank based on an allegation the sale was unlawful. So in other words, the declaration, so to the view of the judge, was going to affect the legal rights of persons currently unidentified and unidentifiable. However, if the court were asked to make a declaration the bank has a common law power of sale, that declaration would not be binding on anyone in a case where there was no defendant to the proceedings. So, having identified the problem, he says at 27, accordingly, in order to obtain a declaration which will be binding on a defendant, there must be a defendant to the proceedings. Will it be possible in this case to have defendants, even if they are not named, but are described in some other way? There is then a reference to Bloomsbury. So the judge says there are many cases which followed that precedent. If the case law had stopped there, the bank would have had a straightforward argument for joining defendants who were described in an appropriate way, but without naming them. However, in Cameron, the Supreme Court pointed out there was a limit to how far that case could be extended, and the familiar paragraphs 13 and 15 are set out, and also 21 and 25. So, picking it up, Mr. Justice Morgan at 32, foot of 3475, Cameron was later considered by the Court of Appeal in Ineos and in Canada Goose. So this would have been decided when Canada Goose was probably the last word on the subject, I think. Court of Appeal explained the categories of case which were relevant for the purpose of determining whether it was possible to join a party using words of description but without using a name. Were not confined to the two categories referred to in Cameron, but there was also a category of case where the court could grant an interim quaternion injunction against persons referred to as newcomers who will commit or were highly likely to commit the unlawful civil wrong, which was to be the subject of the injunction. And it sets out what was said in Canada Goose about that interim stage. 33, in the present case, there's no particular difficulty in selecting words of description for the persons who would be appropriate defendants to the bank's claim for a declaration. Then 34. However, the difficulty comes when one asks whether the bank can locate the actual individuals who come within the description of the defendants and or whether the bank can communicate with those individuals. Prima facie, the bank will not be able to locate or communicate with the actual individuals who come within the description. And then he considers what was said in Cameron about service with an alternative method or dispensing. And the last sentence of the paragraph, that's a problem here because putting a notice up in the safety deposit box room, which seemed to be the main possibility under consideration, he doubted that could reasonably be expected to bring the proceedings to the attention of the defendant, at any rate at any time before they were finally determined. Because unlike with an injunction, liberty to apply wasn't going to be the same solution in a case of this nature. Then 36, as regards the possibility it might be appropriate to dispense with the service of the proceedings under Rule 616, Lord Sumption in Cameron found it hard to envisage a case where it would be right to dispense with service of the claim form, where there was no reason to believe that the defendant was aware that proceedings had been or were likely to be brought. The present is a case where there is no reason to believe that the defendants described as explained above would have reason to believe the proceedings had been or were likely to be brought. I note, however, that Lord Sumption gave as a reason for his conclusion that any other course would expose the defendant to a default judgment without him having the opportunity to be heard or otherwise to defend his interest, which is obviously where I say the analogy with the liberty to apply comes in terms of rationale for the principle. And then at 38, problem in the present case, far removed from the typical case, which would have been considered by Lord Sumption. I say that for a number of reasons. One is no question of a default judgment as an administrative act, not much room for argument as to the facts. Two, it's the defendants really who've left the bank with the problem, and the proceedings are potentially beneficial to the defendant. So the judge decides he can follow the procedure. The particular reasons he gives for regarding that as acceptable and the facts of that case have very little to do with what we are concerned with here. They're of no assistance to me. But what I respectfully do submit I can get out of this case is, one, Cameron should not be treated as laying down absolute conceptual jurisprudential bars. Rather, it should be seen as a case about the courts not doing things which expose people to detrimental legal consequences without them having the opportunity to be heard or otherwise to defend their interests, is what I say can be done in these injunction cases. In fact, I think that's really, I may have said there are 2 points, but that's really the point. And now I am at 12:30, so unless I can insist further, those are my submissions.
Thank you very much, Mr. Giffen.
Lords, may I just have a moment? I've got
Yes,
some
of course.
furniture removing to do. Thank you. Health and safety must come first. My lords, can we go, please, to... Can we please turn to the injunction that was granted to Wolverhampton in this case and focus on some solid facts?
Yes,
It's at page 800.
800. Touching on a point that I was to raise with you, we have a large number number of individual cases here, and we haven't descended until now into any details.
Well, that's what I'm here for, my lord.
Good. I'm very glad to hear it, because we, at the end of the day, we will want to know what sort of relief we should, what sort of order we should be making in these, you know, I don't even know the number of appeals we have in front of us, but we'll need your assistance and Mr. Drabble's in relation to what we should do with them.
There is only, as I understand it, one appeal as such, and that's in my case, in the Wolverhampton case. The injunction at page 800 was a good injunction for the appellants to choose as the subject of the appeal, because in some ways it was the most stark example of a contramundum, of the contramundum effect of a person's unknown injunction. It's addressed to persons unknown, or in the box just below the title to the action, at the top of page 800, to whom it may concern. At the bottom of 800, we learn that any party can apply to the court for this order to be varied or discharged. And that's important. I'll come back to that. And then the meat of the order over the page, it's ordered that, 1, it is forbidden for anyone, whether by themselves, etc., to set up an encampment. And you really don't need to read any further than that. There are definitions of encampment and so on. Over the page, paragraph 3, the order shall continue for 3 years. So it's time limited in any event. It's not going to last forever. And it has now, my lord, expired. And at paragraph 6, that isn't the end of the limitation. There is a provision where it must be reviewed after 1 year. So it was forbidden for anyone to set up an encampment on 60 sites that were named in the order. This was not in the borough of Wolverhampton, but on any one of 60 sites which formed a small fraction of the borough of Wolverhampton. And these were largely sites these were sites that have been identified by those professing expertise in the field as being most at risk. My lord, at the time of the injunction, none of those sites was in fact the subject of an encampment. So, although Wolverhampton had suffered problems for a long time with encampments, so it was exclusively a quiet time at order, and there were no defendants in existence when it was made. It was a provisional order which would come into being in practice, in practical terms, for an individual when either that individual broke it or applied to the court to vary it.
Provisional by that, are you referring to its duration, or in what sense provisional?
In what sense?
Provisional.
It was provisional in the sense that if an individual applied to the court to have their case assessed for proportionality and other relevant factors, then the order need not apply to them, and if they won their application, would not apply to them.
Sorry.
Can I tell you something of the... I mean, this order works to deal with the matters that your lordship raised this morning with Mr. Giffen at the beginning of the morning. This order, I would submit, works via Gemmell or it works via Venables. if there's any real difference between the two, which there probably isn't, except minor practical differences. I'll come back to that. But before I do, can I show you some more facts? Contrary to the impression that might be conveyed by some of the submissions yesterday, this order was not lightly obtained. Before the hearing before Mrs. Justice Jefford, there was a separate hearing before His Honour Judge Cook, sitting as a judge of the High Court, exclusively to determine how the application was to be served. And at that hearing, an order was made, which you can see at page 771. And it's as well.
I didn't catch the page.
771.
Thank you.
So there was to be a website page on the council's website. There were to be links to that on Twitter and on the Twitter and Facebook accounts of the council, a press release, an editorial to be paid for and published in the local newspaper, a video on YouTube at which everything was explained orally, largely for the benefit of anyone who couldn't read, and again a link to that posted on Twitter and Facebook, and 1.6 affixing a copy. And Judge Cook ordered at the conclusion of that hearing that the so-called final hearing would be listed before a High Court judge, that this was not suitable for a Section 9 judge. And that was Mrs. Justice Jefford.
Excuse me, how much notice was given of the application? Because the inspection was to be on a weekly basis. I'm looking at page 772.
Yes. Can I ask Miss Caney that? I'm not sure.
Well, thank you. You come back to me at some point.
What is being served?
Okay, she'll come back to me on that and I'll let you know.
This isn't about service of the order, is it? It's about service of the proceedings.
Yes,
Yeah.
it's service of the claim form and of
Yeah.
the application for an injunction. I skipped the bit about service of the order when we went over the order, because it replicates this, but with a few minor variations. At page 793, you have the extempore judgment that Mrs. Justice Jefford delivered. I invite the court not to be misled by the brevity of this judgment. It's very selective in what it mentions. Mrs. Justice Jefford had 6 lever arch files of evidence. She told counsel at the outset of the hearing that she had read it. It was obvious in the course of the hearing that that meant she had mastered it. The evidence, although she doesn't mention it in her judgment, covered an equality impact assessment. It covered evidence of compliance with government guidance. But in her judgment, Mrs. Justice Jefford focused on the aspects of the case that troubled her, not on the aspects that did not. At paragraph 3, she set out the basis of the application, an increasing number of unauthorised encampments within the area. She says she has voluminous evidence at the top of page 794. She summarises a witness statement of Mr. Walker and gives some statistics as to the number of incursions. And she says, the evidence seems to me to be important, not merely as to the volume of incursions and unauthorised encampments, but also as evidencing the fact that If one site is vacated, or indeed travellers are required to vacate a site, then they'll simply move on and occupy another available site. So that was an actual experience put in evidence which was accepted by the judge. Paragraph 5 describes the type of sites that she was concerned with. The immediate impact, she says in the second sentence, of an unauthorised encampment is to inhibit the use by others of such areas, and frequently, as with the highway, public open spaces, car parks and so on, it is others who are intended to enjoy the land. Second point is that antisocial behaviour is regularly associated with unauthorised encampments. Reports of abuse, noise, nuisance, threats of violence and intimidation. There are numerous such examples in the witness statement. They've included instances where threats have been made, and she gives an example. And that includes travellers climbing on the roof, removing security cameras while wearing face masks. Paragraph 6, she refers to the lack of toilet facilities and the consequences of that. As well as that, there are gas canisters, metal and cable, which can be dangerous. Paragraph 7, she makes the point again that this renders local amenities inaccessible for residents, and emphasises the risks to human health and the cost. She mentions a particular problem in Bilston, paragraph 8, and concludes in paragraph 9 that all these matters together weigh heavily in favour of granting the injunction. But then she starts in paragraph 10 to direct herself as to the matters which she needs to consider. Is it just and proportionate to grant such an injunction? And this is an important finding in the third sentence of paragraph 10. I am satisfied that in terms of the efficacy of preventing unauthorised encampments, there is no adequate alternative remedy. And we invite this court to respect that finding. It's one of the arguments of those who oppose these injunctions to suggest that alternative remedies should be preferred. There is a clear judicial finding that in this case there was none. And it was considered by Mrs. Justice Jefford, and she drew that conclusion.
Can I ask, the context here, is it an application based on tort, trespass or nuisance, or is it based on the breach of planning control or something?
I'm sorry, your lordship has asked me about the one bit of the judgment I've omitted, which is in paragraph 2,
right,
where she discusses that.
Fine.
And in fact refuses to countenance an injunction on one of the grounds that we were asking for. And says that she will grant the injunction on other grounds. One of them is section 130 of the Highways Act, but that's problematic actually. But certainly the other grounds are perfectly solid ones. So in paragraph 10...
so there was a statutory basis essentially for this injunction?
Well, there was, but I would argue this case mainly on the basis of the tort of trespass. There is a statutory basis in section 187B,
yeah,
which, to my case, I think Ms. Bolton's going to deal with this, to my case adds nothing.
Yes, I mean, insofar as it was based on section 130 of the Highways Act, the sites presumably covered weren't simply highways.
That's right.
Yeah.
Yeah. And also, it's only an offence to obstruct the highway if you're being unreasonable.
Yeah.
And that raises too many questions that can be answered at this stage. But in paragraph 10 then...
And the breach of planning control is what the caravan sites or the like are in a different use class order from public open space.
Yes. In paragraph 10, this is before Bromley, But Wolverhampton had drawn to the judge's attention, Miss Caney, who sits behind me, had drawn the judge's attention to the problem that she had to overcome, which is that you can't have these injunctions if it excludes gypsies and travellers from the borough. You can't stop that minority from living their life in Wolverhampton. And so she considers that issue and concludes at the end of paragraph 10 that this order would not exclude gypsies and travellers from Wolverhampton. Paragraph 11, she mentions that there's going to be a transit site. There isn't one yet. There is now, but there wasn't then.
I'm sorry to interrupt you again, but we haven't been addressed on the statutory regime that places obligations on local authorities to provide sites. It'd be helpful at any rate to have a note of what the relevant provisions are. So at
Yes,
some stage.
I'll see if Ms. Caney can prepare that. I'm not sure there is an obligation to provide them, but if you don't provide them, you can't use certain provisions of recent legislation.
Yes, there was something mentioned, I think, in the injunction itself. At the review, the council had to explain what progress had been made in establishing official sites.
Yes. That's in paragraph 13 and 14, where the judge, I just don't have time, I'm afraid, to go at the pace I've been going at. I've got to speed up. So I have to ask the court to read the rest of the judgment down to paragraph 14 when convenient. But the outcome is I'm not going to make an injunction without reviews, because I want to make sure that the transit site happens, and there'll be a review after 1 year. And in fact, at the first review hearing, not very much happened. Progress was reported on, but it may be of interest to the court to know that counsel and the judge, Mr. Justice Stuart Smith, treated that as an ex parte hearing, and counsel confirmed to the court that she was complying with her obligations to the court, which arise when only one side is represented. Now, my Lord, there's been no challenge to this order by any gypsy or traveller on the ground that they have been disadvantaged by it, or on any other ground. It would have been open, of course, to those who have brought this appeal to have sponsored a family to challenge Wolverhampton's order and to demonstrate that their Article 8 rights demand that the order be discharged. But that hasn't been done. And the absence of such a challenge, in our respectful submission, lends an air of unreality to this appeal and weakens the proposition that these injunctions must be taken by this court to be inherently unfair. That there is no factual basis, whereas there could have been a factual basis for that contention. Similarly, Lord Kitchen's example of the Anton Pillar problem of self-incriminating material having to be given over and the problem not being appreciated at the outset. Well, no such examples have arisen in this case or in any of the other injunctions against persons unknown to stop encampments in the many years that these injunctions have now been with us. And again, I'd respectfully suggest that speculating about the problems is seeing ghosts in shadows.
I appreciate it doesn't affect your situation in a traveller case as far as I know at the moment. But the problem raised, I mean, An example of a problem is the one that was raised yesterday by Council for Friends of the Earth, where if a local authority used its statutory powers, it could in principle be judicially reviewed and by an organisation like FOE, and it could then apply to the court for a protective costs order. Because these proceedings take the form, I'm not meaning specifically the traveller proceedings in relation to Wolverhampton, but because there is an alternative based on the tort of trespass, which takes a form of civil proceedings, that form of protection isn't available, although it could be provided, I dare say, in other ways. But that's something which a court ought perhaps to be thinking about, if it's agreeable to allowing the local authority to take advantage of civil proceedings rather than ordinary civil proceedings rather than JRs, and consequently shutting out a protection which an environmental organisation would otherwise have.
I appreciate the concern. Certainly, if a judge said, if Mrs. Justice Jefford had said to Ms. Caney in 2018, if somebody wants to challenge this order, you're going to have to enter into an agreement not to ask for costs, then there wouldn't have been a problem. I don't have instructions, but I'm sure there wouldn't have been a problem with that. If Ms. Caney had said no, if they want to challenge this, they're going to have to pay the costs if they lose, then no doubt she wouldn't have got the injunction.
I'm trying to work out if this is an interim or a final order. It's in fact an order made under a Part 8 procedure without any provision for a return date other than a review of the council's compliance with its finding transit site obligation and an expiry at the end of 3 years.
Yes.
I mean, it has all the trappings of an order which wasn't interim in the sense that it was just holding any fort.
Absolutely.
Yeah.
It's impossible to categorise it as one or the other.
Yes, I mean, it doesn't look much like a final order because no one's been...
No.
Well, I'm not quite sure whether you say anybody was served or not served. There was an elaborate provision for alternative service.
Yes.
But there were no named defendants.
No. Well, no one was served in the end.
Well,
because until somebody came to breach it, I'm not sure that actually ever happened. It was a very successful order. But
well, it worked. In other words, it had its effect.
It did.
At a time when no one had become named defendants.
And it was nevertheless open to such people, if they felt disadvantaged by it, to apply to set it aside. If time permits, I'll deal briefly with the practicalities of that in a moment. Now, it's true that the proportionality assessment which Mrs. Justice Jefford attempted was not as full as it would have been if she'd had a family before her with evidence of that family's needs. But local authorities don't apply for these injunctions in this form because they want to steal a march and a litigation advantage. They do it ex parte because that is necessitated by the nature of the wrongdoing which it is necessary to restrain. And there is no other way of doing it. People who set up these encampments don't phone ahead to warn Wolverhampton that they're on their way.
That's why I was wondering about the time that was given of the application, because if weeks of notice were given and yet nothing was written to the council to say we're concerned about this or we need to have representation, then it may be a factor in your favour.
Lord, 10 weeks' notice was given. 10 weeks. Service was completed by the 23rd of July, and the hearing was the 2nd of October.
So those dates again are
The service steps were completed by the 23rd of July. So everything that was required had been done by then.
Yeah.
And the hearing was the 2nd of October.
And the notice was checked every week as presumably the application indicated that it would be.
Yes, Mrs. Justice Jefford made a specific finding that the service provisions had been complied with.
Yeah.
So the position is that the proportionality assessment isn't perfect because it can't be, but there isn't another remedy. This is the remedy that the courts have been fashioning ever since Bloomsbury, starting with Bloomsbury and ever since, and even earlier in a certain more narrow field. And now the appellants are asking this court to throw that remedy away that the courts have been fashioning for so long, and do not once in their written case or in Mr. Drabble's submissions suggest a cogent alternative remedy to Wolverhampton and its residents to stop this sort of behaviour. It's also quite difficult to believe, I submit, that members of the relevant communities have as strong an appetite as Mr. Drabble would have you accept to be involved in litigation of this sort. Experience shows that wrongdoers actually conceal their identity to prevent identification. And if we could go to page 991. There was evidence of that not in the hearing before Mrs. Justice Jefford, but before one of the review hearings. 991, paragraphs 55 to 56. This is specific evidence, which is why I've taken you to it, but it was it was part of the pleaded case for Wolverhampton that this was one of the problems, that they couldn't identify people because those who perpetrated these trespasses actively prevented themselves from being identified. Police Sergeant Plumridge explains what happened on one occasion.
So which paragraph are you looking at?
90. It's the end of 56 is the concealment.
Thank you.
Oh, this was before Mrs. Justice Jefford. It's not in that part of the bundle, but it was. Now, the success of this appeal, if it happens, will ensure that these tactics work. Indeed, to remove from the armoury of the courts the remedy which the courts have devised over the last 20-odd years would be to incentivise this sort of behaviour. And in our respectful submission, the Supreme Court should not be prepared lightly to announce that the law of England and Wales knows no remedy for this sort of conduct. What these appeals are seeking to do is to say that the guidance in London, you can forget about it. It's pointless because it can never work. And instead, balancing exercise won't be carried out by any independent party, but the travellers who are prone to commit these trespasses, a small proportion of the overall community, they can get to decide for themselves where they camp, and they will not be subject to being prevented from doing so by the courts. That's halfway, my lord, in time.
Very well. We'll adjourn then and resume at 2 o'clock.
Thank you.